pleasant good morning and welcome to the CCG Hour. It is just great that we can be here another Friday morning. Well, some people are happy just the fact that it's Friday. They don't care if it's Friday morning or evening. Once it's Friday and the week is almost at an end and they can relax and go home. Well, I can't relax yet. I have a beautiful guest with me. Right now, she's becoming no stranger. Niaesha, good morning.
Good morning, Wendy. Good morning, viewers.
Wonderful, you see. And she's all ready now because after the first program that we had, I know for sure that she's like, yes, let's go. Actually, I'm really, really excited. For those of you who caught our program the last time, we started to talk about land and so forth, but I'm going ahead of myself. Niaesha is the legal counsel for the CCG, and after a while, I finally got her. Now she's here. Well, she's here to stay. So we will continue where we left off last month. So just a little backdrop as to where we were. So last month we talked about interest in land. We spoke about what are the different kind of interest we have in land. And we're not going to go into it in detail today, but she will mention that just to kind of keep you abreast in case you didn't catch the first program. And of course, we started to look at how you actually get a title and so forth. Today, we are going to look particularly at, we hope we'll get to taxes and so forth that are associated with land, but for sure we'll be looking at how do you acquire land in the first place, right? Because we really do believe that there's a lot of questions concerning land, and as we said in the first program, so much confusion concerning land. Oh boy, it's always drama concerning land. So we want to help you so that when you are dealing, especially with family members and so forth, you know you are well informed and you can go about your business. And the truth is, as much as I'm not so sure if Niaesha would love to hear that, based on what she's telling you, there are some things you might not have to go to the lawyer to ask.
that is so.
Of course, that might mean
not to the advantage of lawyers who obviously want to make some money.
But it is the truth. There are some simple things that if you do know it, you may just avoid a trip to the lawyer. But that doesn't mean that we don't want you to go there. It just means that we want you well informed. And when you do go, you actually going and you know what it is that you're asking for. You know what you're about so that you can understand what the lawyer might be telling you as well. So that's enough talk for me.
Thank you so much. Thank you, Wendy.
Yes.
It's good to be back. It's good to be discussing this area of law. I am very excited about it. I practice a lot of land law, and most lawyers practice a lot of land law in Grenada, and it's a very interesting area, and I know our viewers probably have so many questions, so many areas they're interested in, so many things they probably have misconceptions about, and I'm hopeful that in today's exercise I could clarify some of the things that they're wondering about.
Definitely. So my first thing, of course, sadly I don't have land right now. But I had land, and I remember we got it from my mother-in-law.
Right.
She wasn't even finished paying on it, so that was a whole story. And I'm deliberately starting there, not to tell you my business, but just because I really believe that, having thought about that, I was like, there are obviously a whole lot of ways or conditions under which you can acquire land. So let's go there. So like we could start with my case. So she got land from the government, and that's when we say in Grenada the government, I suppose we have to make sure we could explain that as well. What does that mean? Because it didn't mean that the government was just giving away land because we had to pay for it.
Right.
But it was a small portion of land that was, I think it was like it was a residential area, it became, and then of course like they cut up the lands and whatnot, and it was sold for. Oh, well, you see, there we go. Thank you very much for the term. You see, I saying cut up, and that's what we tend to say. They cut up the land. It's subdivision or subdivided. Thank you very much. So, right. So let's start possibly with that one, and if you can go, as I said, all the different ways that we can think about the different ways that people can acquire land, and what do you as an individual have to do? What are some of the things that you might have to do in order to, to make sure that you're in line with the law as it relates to that?
Okay, so we'll start with a simple sale, right? Which is one of the ways that you would acquire land. And from the example you've given, your mother-in-law would have bought land from government by a sale. So the document that will evidence title once the land is paid for would be a deed of conveyance, right?
Okay.
Or indenture of conveyance. When it comes to land from government, you really would not get your conveyance until you complete payments. Most persons who are residing on a lot of land and government decide they're going to allot that piece of land to one particular individual, they would pay on account usually.
Yes.
So they would have an allotment done, and it's sort of a longer process because you would have a cabinet, you would get to a cabinet conclusion to decide you're making this allotment for this lot A to, let's say, call the person B. So you'll divide the land into several lots. So if you have an estate, number the land in numbers, and let's call the persons by the letters in the alphabet.
Okay. Right.
So let's say there's a piece of land in Mirabeau,
right,
and it is owned by the state. The state will subdivide the land. They will have their surveyor survey the entire area,
right,
and they will subdivide the land into numbers 1 to 10.
Right.
Okay? And parties A to, I'm not too sure which would be equivalent to 10.
Go ahead, I'll
A, B, C, D, E, F, G. Each person will get an allotment.
Right.
Right? And the government would have probably met, would have met in the cabinet and made a decision, and there would be a cabinet conclusion giving party A lot 1, party B lot 2, and so forth. Now you would pay your for your land through the treasury, right?
Okay.
And where you would keep your, obviously you would have a book, they would make entries of the payments, and you would have your receipt to show your payments.
Okay.
Now that goes in tandem with the Ministry of Lands, because they will have the larger plan showing all the different allotments, and when you finish pay for the land and you pay for your plan, they will give you a copy of that smaller plan showing your lot 1.
Okay, quick question. So if the person is not having the indenture, you call it?
Indenture?
Right. If they have to, so you purchase the land from government, you're paying on
You're
account
paying
still,
on
but then
account.
how do you get, let's say you have to go and get a mortgage now.
You will not be able to get a mortgage once you're purchasing land from government, unless government also meets and the cabinet decides to allow you permission to get a mortgage, because there is a restriction when you're getting land from government. You're not able to the last time I spoke about the word disposing, you're not going to be able to part with the land for another 12 years. Really? You have to keep it until you can, you have to hold on to the land, and after 12 years you can sell it or otherwise dispose of it. So if you have to get a mortgage is a form of disposing land. You send in the title to the bank. So you will have to get permission from government to do so.
Wow.
Now remember, if you have to use a mortgage to buy the land, or if you want to construct a building and you need a mortgage, you must get consent from government. So you cannot purchase land from government and just dispose of it, because you can forfeit it. They can take it back from you. It's probably happened in our history. So you want to ensure that you finish paying for it on your account, and once that is done, then a deed of conveyance would be prepared, and the Governor General is who would sign the deed on behalf of the state. So that's the simple way of land ownership, given the example you give.
Right.
Less complicated if it's a private treaty, private sale.
Yeah,
right?
clearly.
So you and I are selling you're buying a lot of land from me, I'm buying a lot of land from you. You would just do a sale agreement, which a lawyer can draw that up for you. And you have the sale agreement, and usually your payment time is a lot shorter. The 90 days is a usual time period that they will give in a private contract.
Right.
And that's sufficient time if you're getting a mortgage. 90 days in which to get your mortgage, and so that you can pay the person, because a seller would not want to wait 5-10 years to get their money, but government may, because there are lands that are allotted and people taking their sweet time to pay, because they're just not in a position to pay large payments.
Right.
And but government will not, you will not have suffer any bad consequence usually if you're taking a while to make your payments, once it is that you keep paying.
Right.
Right?
That 90-day period, that's a standard amount for a sales agreement? Is that the case?
Generally. It can be shorter and it can be longer, but it has to be by consent of the two parties.
Okay.
They can
All right.
agree other than the 90 days. But it's advisable to do 90 days because you want to have some sort of bind on both parties. You want to ensure, and not usually, let me just go back to say, when you sign that contract, you usually pay a deposit. The seller would receive a 10% deposit from the purchaser. And that amount is paid, or a amount is paid to hold the sale, to bind both parties over. The seller does not want the sale to not come through. He wants to get the balance of his purchase monies.
Of course.
And the purchaser, the person who's buying now, doesn't want the seller to sell to a third party, another person. So, of course, once they pay a deposit, you have to hold on to the property for them.
Right.
And 90 days is not unreasonable.
Right.
But of course, you can do longer or shorter
if you make the arrangement.
If you make the arrangement.
Okay. All right.
And in that way, once your sale agreement happens, you will do your searches in the registry. I do searches one way or the other. Once I'm doing a conveyance, it doesn't even matter. So even because I always like to see what's the history and the title. So even if it's it's a piece of land that is owned by government, sometimes it wasn't always owned by government, because sometimes government does acquire land from private people.
Okay.
Sometimes they may buy a piece of land that was as part of an estate that was owned by a family.
Right.
So sometimes you want to go back to check the title, just in case there's any defect in the title. Sometimes there is a defect in the title and someone didn't pick it up along the way, and you may read the document and say, there is a problem. So you fix it one time.
Oh, okay.
I like to be thorough. And so I would do that. And then you prepare your conveyance. The purchaser's lawyer will prepare the conveyance, and the seller would sign the conveyance to convey to them. Of course, they will get their payment on signature.
Okay, so it cannot be done, this simple private arrangement cannot be done without a lawyer? Is that the case?
It's advisable to get a lawyer, because a conveyance is not really a very simple document.
Right.
And so it might be a little tricky for a lay person to draft a conveyance.
Okay. So if I have to, so I want to purchase a piece of land from you. Well, actually, you're not the best example because you are a lawyer. So let's just pretend you're not.
Lawyers generally get others to prepare their conveyance.
I don't understand.
If I have we get a friend, a colleague. So if it is that I am getting a deed in my favor, I would tell one of my friends, please prepare my conveyance for you. For me, I've done this search. This is my search report from my search clerk. This is a draft. I'm sending it in electronic form. You can do with it what you want, but it's your because your name is going to be on it. But I've done some homework for you.
Right.
Because it's something I can do, but you don't really want your name to be prepared by.
Exactly. And then you have to still sign. So that is what I was wondering.
You just have somebody act for you in the matter. And I just wanted to just stick this in before I go on to talk about how else you can acquire the lands, by saying it's not so expensive to purchase a piece of land in terms of getting your conveyance done, your legal costs. Because you have your sale. Let's say you're buying a piece of land for $100,000. Your cost of your conveyance is 2%. So it's and lawyer may give you a discount. So the legal fees is 2%, and then you have other things to pay, like your stamps and so forth.
And you pay that through the lawyer.
You pay that through the lawyer. That is a disbursement that goes, whether it is to government or so forth, consideration, etc. So there's stamps of consideration, which is 1% on the conveyance. And, so the cost, sometimes people think lawyers are so expensive.
Well, yeah, that is
but
the thought.
Costs are regulated by the non-contentious scale of fees, right? So that if you have to pay your lawyer, the lawyer would pull out the schedule of fees for non-contentious work, business, and they would tell you a conveyance, 2%.
Okay.
A lease, usually a lease is 1 month's rent. So if you know or 1% consideration.
Okay.
So you kind of know
So
in
no one-
advance. Lawyers don't just come up and
That
make
I
up
was
a
just
fee.
about right. So you can't quote unquote a lawyer cannot cheat you. You know people.
No, no.
And then it's based. Okay, so you use the example of the $100,000. So
Yes.
it's based on the cost of
The
the land.
land,
That the
yes.
percentage. Okay.
Yes,
All
and
right.
I laugh because the realtor, the real estate person who's looking for the land and got the land for you is likely to make much more than the lawyer, because
Oh, yes,
the
they do
realtor
make.
gets 5% commission on the sale, and if there are listing fees, there might be another additional fee. I'm not too sure, because it's based on how the company works. They may
Right.
have other fees that are not just finding you the buyer. Maybe they may have a charge for if I list you on my website and you've been
Right,
listed for a
right.
year. Maybe I might have a nominal fee per year for having you listed. And then when I find you a buyer, then I charge you 5% on the sale. So you see, and then the lawyer is doing all the little groundwork and so
right.
forth, and that is 2%. So it's not as expensive as one would think. And when you think about it this way, and you think about what it will save you and the peace of mind you will have, it's better.
It's better.
I always say I'm not going to try doing a surgery on myself. So in the
like
same
that
way, if you have a legal problem,
Well, except it's maybe just your toe.
well, I wouldn't use a
Even
knife
then,
and try to cut
I
it.
know, right?
Just a little bit of humor here for
Yeah,
you.
no, but definitely,
But you
yeah.
definitely want to ensure that you have the peace of mind that your work was done properly.
Okay, quick question. I'm going back a little bit because I use you and then that is how we got there. But so we are just two regular persons in the neighborhood. I have a piece of land to sell. You want to purchase. We both have the idea that it's not a good idea to go to the lawyer.
Right.
Because
That
we
happens
could- yeah,
most,
we could
most times, more often than you think.
More often, okay. Sadly, I'm sure that's unfortunate, but still, we both assume, oh, it's no big deal. We know each other.
good and we trust one another.
There
We
we
good.
go.
No
And
problem
so,
could happen.
And so I just have my receipt book because I mean
Right.
we're legal.
Yes,
In
so
a way,
you
we
write
think
your receipt,
I
you
write my
collect-
receipt. I get my
collect
money crazy in
$100,000.
cash. It's crazy too because I didn't even ask where it came from. But anyhow, let's
Yes.
just say I got it or
Yes.
however it was done. The point is that I have my money and you have your receipt.
Right.
That's it.
And you go in
Is that
possession of
leg-
the land.
Yes. Is that legal?
Well, let me put it in perspective with what how land ownership goes under the Act,
Okay.
and then we will
Define
answer whether it's legal or not through that.
Okay.
So ownership of the land is regulated by the Deeds and Land Registry Act. So that would tell you how you come to have title in your name.
Right.
And it speaks to having your conveyance registered and recorded in the Supreme Court, in the registry, in the Deeds and Land Registry, the Deeds and Land Registry. So that receipt, so to speak, will not be in the correct form. Let me put it this way. Let me be very diplomatic. It would not be in the correct form so as to be recorded in the registry.
Right.
And if it is not recorded in the registry, it will
You
not form
technically don't have the
legal
land?
title. So to answer the question, having said that, the short answer is no, because you would have entered into possession of the land, but you have no legal document proving your ownership. The receipt is evidence of a sale. But it is not.
But it doesn't mean that
it
I
is
technically
not
own the land?
legal in title for the land.
Oh boy. Okay.
So that is earlier I described the document you will have and its form. It starts out who prepares it. It tells you this indenture is made. It will give you a date. This date. It tells you the parties between party A and party B, and it gives you the address so you can find them, that you can locate them where this person are, and it will
Right.
tell you in what capacity. So who is the vendor and who is the seller? And that's the first clause, first paragraph. And then the next paragraph would give you recitals. We call them recitals. That is a description of the events which lead to the sale.
that, right.
So it would say that they had an agreement, which is the private agreement we spoke about, the sale agreement. They agreed to sell, one party agreed to sell and one party agreed to buy lot A, lot one,
Oh,
lot
yeah.
lot one to be consistent, lot one for this price. And they've agreed to sell at this price. So that's the recital, and they've agreed to execute this document, this conveyance.
Okay.
And then the next paragraph will tell you that is the part that gives effect to the intention. And it will say, no, this deed witness it, and it will say that this vendor, this person has paid this money, this consideration, which is the $100,000, and the vendor, the seller, will acknowledge receipt of that money. So that part is like a receipt,
Right.
what you signed in the book. So that part now is the receipt. I've received the $100,000 receipt. I've acknowledged, and I'm now conveying. The vendor conveys as a legal owner, as the beneficial owner, is conveying the title to you.
Right.
Right, of this lot, and it would describe the lot of land again, and it will even describe what is in the plan. It would say as shown in the plan or diagram attached here too, and they will mark the plan. If your party name is AB, it would mark the plan AB with this diagram attached, and it will say how you are holding the interest. You're holding it fee simple in possession. Right. Remember last time I have spoken about types of interest. The fee simple, possession of the land, and that would be your then the next part of it would just be for your signatures. In witness whereof the vendor has affixed his signature, he's put his signature. But the language is a lot of legalese. So I'm trying to break it in very simple
it's okay because
way because they're actually names. Like if I say the testatum and all the legal words, everybody's going to say, what is she saying? I'm not understanding. So I'm just trying to explain what it is. But when you prepare the document, it looks very, very official and almost intimidating.
Yes.
And the person would sign, put their signature, and there's a way to sign this as well. You have to have a witness to see that you've signed it. So you too, in your private capacity, cannot
do all of that.
The purchaser cannot be the witness to the sale.
But
because that
illustration that I gave, I'm sure it has happened
over and over again. And
so
it's
what
very
kind
dangerous
of problem comes as a result of that?
So a major difficulty that happens is that after persons have been put in possession of the land, so you bought your land and you've received and you're on the land, and you work in the land, you put a house on the land. Let's say you put a wooden house on the land, and heaven forbid something happened to your house. There's no house and the land becomes unoccupied and you die. You know, let's say you travel to meet your children in the States and you didn't go back because your house fell in Ivan. So there's nothing on the land. So to show your ownership becomes really tricky because somebody else could go on the land and say, please, and you don't have your legal
because
title,
all I have is still this one receipt that we...
And no one has notice of your ownership. So what they would see when they go to do the search in the registry is the person who sold the land to you. That is the last title holder. And if I went on the land while you were by your children, in and out of your land, then I could acquire possession against you. Because the title would show the last owner to be the previous person, not you, because you did not register your ownership of the land. So there's no notice that you're the owner of the land at all. And you can lose your land this way, for obvious reason. Another simple way.
Hold on, you can let's just stick a pin on that. You can lose it.
You can lose the land that way because
to whom? To the person
who's been squatting and going on and on because the other person they've already sold the land to you and they've probably moved on with life. You know, sometimes years or dead, and the children may never know of the sale. Because sometimes these sales happen and their family do not know about the sale. This happen between friends.
Yeah, exactly.
In
and
the
that's
community
the trouble.
of friends.
Yes.
So you got older, like I said, your house fell in Ivan, your daughter in the States say, come and live by me, daddy. And you never regularized, but you told your daughter you have this piece of land here.
Yes.
And you give her the receipt. So now when she comes back and she wants to put a house on the land, to put a vacation home.
Yes.
No evidence. You have to try to find the family of the person who sold it, and then this other person comes and say, well, I've been on that land, you don't own it, I didn't see y'all haven't come for all these years, you know. And we mentioned possessory title, which is a long topic that we have to do on probably another occasion. So that person acquires. But even without that, you have a simple problem where it is difficult to find someone now to, what I would use this word, regularize the title. So you have this, the previous example I gave, which is kind of almost a conflict situation
Yes.
where somebody's claiming possession against you.
Yeah.
But you have the simple situation where these two generations have died, and now the beneficiaries are trying to regularize the title. And to get the signatures for that, let's say each person had 8 children.
Oh my.
So the seller has 8 children, and the purchaser had 8 children. It means that the interest in the land from the person who sold the land has passed to 8 persons. And the beneficiaries for the land, the person who bought the land, has 8 persons. So you have to find these 8 persons who who sold the beneficiaries of the seller to sign the interest, because remember that land is now owned by them,
By the
collective 8.
The first person
because the first,
is
they're the
no
beneficiaries of the, and they have to
Oh
find them,
boy.
who may be in different parts of the world. You may not have their addresses, and if you miss their signature, any one of them, your title is defective, because because the land is
Even if they don't know about this whole
even if they
piece
don't
of
know
land
about
business?
this, and that is the trouble. So you may find a lawyer
Wow.
trying to go the easier route, which is to do a statutory declaration to say your father owned the land, but that's not good title. That is not that is the defective title.
So-
it is just showing possession of property, but it is not showing legal interest in property.
Hold on. So, well, with all of this now, I had a simple question here, which is how long does it take? But I'm already seeing that
It's
this
taking
can
a long
take
time,
a
and they have
very
to
long
convey
time.
to all of the other 8 beneficiaries of the purchaser. You understand? So you need the 8 signatures of the seller's people, and they convey it to these 8 persons. But let me tell you, when
But who really
the land may
owns
not be
it?
very big, so the
Oh,
beneficiaries of the purchaser, who's his 8 other children, they want each share that they're now acquiring might be very small
They can't
interest.
deal on it for sure.
And,
baby.
and so it may be better for somebody to buy off their sibling, because it becomes, and every time you go down a generation, it becomes you sharing it up in more persons. So it's very important when you're buying land to get your conveyance on your name, right?
Wow.
And that would save you having to go back to regularized title by finding the beneficiaries of a deceased seller. And it's the same rule that applies if you're buying land from a company. Because a company can, of course, the directors would sign your deed.
Yes.
And maybe not, of course, but the directors would sign the deeds for the company. And or whoever is named, listed as the person who prepares and signs his legal document. And that company is an individual. It's seen in law as an individual,
Right.
just as a person.
Yes.
So if that company goes defunct, then you have a similar process with trying
Oh,
to
my
get
word.
signatures. And obviously, there are rules which govern that too, because law is rules. So if for whatever reason this cannot be found, these persons can be found, you do have the alternative to get a vesting deed that the registrar for deeds and land registry would sign to vest the land to you. But you want to show that you've explored every and all avenues. You left no stones unturned to get to that stage before you get there.
Niaesha.
So
Just listening to this alone, you would be thinking, just do it right
to the first
in
time.
the beginning, because just the thought of what you're saying, I'm not even in a situation, well, I don't have land, but just the thought of it, it's like if you have to go through, or the possibility of having to go through any of what you're explaining, just go to the lawyer.
Yes.
For me,
Yes.
please.
Because,
No, for real,
and
because
sometimes
it sounds
clients
tedious.
feel it is taking so much time, but I bring the document by the lawyer.
Yes.
2 years gone, 2 years gone.
But it's all
a
this.
lot of different homework. And the problem too is that the lawyer may not know the information. So to get the information, you may not have it, and they have to try to find this information for you. It takes a whole investigation to find out who are this person's beneficiaries.
Hold on. So who pays? Okay, so if it takes longer, do you have to pay more? No, for real, because I'm thinking it's taking much longer than the plan.
I personally, I
Right.
can't speak for all of my colleagues, I personally don't charge extra for the time that it takes. what we do is we charge for the document we've prepared. So you probably
word.
will make a loss because you take all this time.
Because that's what you're talking about is a long investigation.
You can probably, if you have to write the different beneficiaries, you can charge for your letters that you've written. But it still will take a lot of time and effort. That some of the costs, it's very difficult to bill your clients. If you're billing by your hourly rate.
Oh boy, okay.
But so you understand.
Yes,
so that is
yes.
why I wouldn't charge a client for all the billable hours because it's going to be a ridiculous bill.
Yes.
So I just, and most persons who are in this situation are not able to afford. First of all, it took a lot to just go to the lawyer to pay this 2%. And then you pay the 2%, you find it, you have to send it to England, you have to send it, they will pay the disbursements for Korea. But you have to send it to this one. You have to send a letter in advance to tell them you've been instructed by this person, who is the beneficiary of this person, who bought land from your father. And so we're in the process of regularizing their title, and we need your signature. So, and sometimes the person didn't even know about this piece of land. So you're giving them information, news that they didn't know. And
that has to be processed again.
And then they have to accept that this transaction happened.
Oh boy.
Because remember, you may have the receipt, hopefully, but what if it got lost in the house when it was destroyed? And that's a common thing that happens. These old papers, people may have had them among the documents, and there's a fire, or there's a storm, or there is some flooding, or just wear of time, because a receipt is not, it might get mold, you mightn't be able to read, sometimes it just got damp and you're not able to read what's on it. It's destroyed. So you don't have that record. Now remember, when you're recording your deed, a copy is always left at your Supreme Court, at the Deeds and Land Registry. I often say the Supreme Court Registry, and it's probably because the one registrar deals with all the different registries, so we kind of use it, but it's a separate function. So the Deeds and Land Registry would have the copy, the identical of your deed. So even if you lose it, you can get a copy of that.
Yeah, but
your receipt that is lost,
exactly, because in that case, they're still getting back only the original, the last owner's
yes,
so it's not
exactly. It's not going to show your title.
You.
It's just going to show it's no proof for you. It's going to show the previous owner. So once you want to buy land, get a lawyer.
All right,
that is one form of ownership.
Let's take a break. I just need a break. No, but it's a lot of information.
It's a lot of information.
But let's take a break, and then we're going on. And this is only one way of ownership. Well, this is the second way. Sale.
The sale. We were talking about the sale, and we gave two examples, whether you're getting land from the government, like public, or private individuals.
And that got us so far. Okay, let's take a quick break, and we are going to be right back.
You are my strength.
Committed Catholics, listen to us.
The youth like us must be given a hearing.
I am a farmer and I have a story to tell.
I'm a farmer and I too would like to share my story.
Even though we walk out there Sunday to Sunday, we too have a story to tell.
I am a Catholic sometimes and I have things to say. I need someone to listen. I have a lot to say on behalf of single parents.
The Catholic Diocese of St. George's in Grenada has begun the synod process. Pope Francis has involved the Universal Church. Your voice is important. Come, share your story, your experience, and your expectations of church.
Well, we are back. Thank you very much for staying with us. I know you are as intrigued, more than just interested, intrigued as I am. Of course, I'm starting back with the same point we took the break on, which is you're about to purchase land, get a lawyer. Because after what Niaesha just explained, there's the peace of mind. Pay your 2%. You hear? Not 20%. Your 2% to get a lawyer, you're paying for your peace of mind. No, for real. Pay for your peace of mind. Okay.
Yes.
So that was the sales. That was only one way of acquisition.
Yes.
Let's go to the next one.
Right. So I could laugh along while I'm talking about complicated land matters.
Yes,
but
you
the
go ahead.
average viewer have heard
It's
what
not
I've
funny.
said, and it is sounded very complicated. And oftentimes, because I always like clients to understand what I'm explaining to them, because they're complicated concepts. And I was just saying to Wendy during the break, I draw. So I take my notepad and I start drawing diagrams on my notepad to explain to them the land and how you subdivide land. And I often start, when we're doing regularization of title, with a family tree.
If you could find the people in the family.
Because sometimes it's a grandparent. So, so if you have acquired land in this way, by a sale, you need to find the original owner, and then you need to trace who are the beneficiaries. So I start with the original owner, and then my mapping goes downwards to who are benefiting from this person. It sometimes gets very complicated. Sometimes it goes 4 generations down, and their cousins and all sorts of things.
Wait, so they would get involved too?
If for instance, the original owner is a grandparent of the beneficiaries, so the legal holder, remember we had a legal holder who's the last registered owner. If that person has died and their children did not get the land conveyed to them, and that's another way you can own land. So before I go on to that, let me just say that you can own land from an inheritance. Right.
So sale is one.
Sale is one, and an inheritance.
Right.
Okay. An inheritance happens when somebody dies. You would get the land from the person who has died. You can be the children, which we call issues in law, or the spouse, right? Or it could be both spouse and children, as the case may be. So party A dies. They die. They had a wife. The wife would get an interest in the land. If they had a wife and children, the wife and children will get an interest in the land. So they've inherited the land from the person who's died.
And if it's a friend or a church, for example, a charity,
Charity,
do you still call that inheritance?
The charity, the only way you can acquire through if the person has left a will.
Okay, so we'll go into will.
Right?
That's another
so
day.
if you've inherited under probate rules, so the other rule I was giving you was based on if you didn't leave a will, so it's intestate. The person has died on the laws of intestacy. Right?
Hold on, that's the inheritance one.
That's the yes.
So
well, so let me start by saying when somebody dies, whatever they own has to be disposed of, given away. Right. And how it's given away would depend on whether they made a will or they didn't.
Okay.
If they made a will, the inheritance will go through the probate procedure.
Right.
So you would inherit, so you're using the word inherit, but you inherit based on what the will says.
That is it.
And that is how the church would be able to get a piece of land from the will.
Or whoever.
Or a friend.
Right.
But if they did not leave a will, even though they intended to give the church or a friend the land, they will not be able to get. It will go through the
just who is
beneficiaries under the intestate estate.
So if the person has no beneficiaries,
that's how it goes back to the state. And the last time I was talking about going back to
the state,
right?
Okay.
So the person.
But how long does that take to go back to the state? It just automatically goes back to the state.
I did not walk with the rules, but there are about 6 categories. You have siblings. It goes to the parent. If the parent, so it has rules
to go
under the
intestate.
Yes.
Right.
So
if it doesn't fit, then
yes.
Okay.
So it goes. If a person has a spouse, it goes to the spouse. If the person has a spouse and children, half share goes to the spouse, half share goes to the children. If they have only children, that is issues, it goes to the children.
Right.
If they did not have children or spouse, it goes to their parent, one parent or both parents. It depends on who's alive. If they didn't have parents, I think it goes to siblings of the whole blood. If it doesn't go to
the whole blood, what does that mean?
Both parents.
Okay, right.
So sorry.
All right.
I'm sorry.
Interesting. No, use those terms so that we'll be able to ask what it means.
Yes, and if it does, it goes to the siblings of half blood, half parent, right? And I think it goes about maybe 1 or 2, which I've probably don't do it every day, and then it goes if nothing, then it will go to the state, the crown. Okay, so that is on the laws of succession. You know, like how the queen passes on in succession, or title, or reign, or right. The same thing happens with every individual with whatever you own, whether it is your personal property or your real property, which land is real property.
Right.
Right? So we call it realty. So when you go to a lawyer, you can say, I would like to do a will. I have personality, which is my personal property to dispose of, and I have realty, which is my land, and the lawyer was very impressed, but you viewed this program. And you just say, oh, what lands do you own? What realty you own? And you would say, I have a lot of land in Birch Grove, and I have a piece of land in Bunjaloo, and I have 3 children, and I have my spouse. And then they will tell you how, and you will tell them what you're interested in, and you will tell them, and I would like to leave this for the church. I have some monies in the bank. I would like to leave this for the church and the Conference of Churches in Grenada to continue its mission and its work. And I'm not advertising for the conference at all. So, and that will be, because if you don't, then the conference is not going to get that
even
that
if you
money,
had intentions.
even if you had your intention, unless it is that your family members knew your intention,
right,
and they wanted to give you know that intention, but it would still be conveyed to them, and they will give it as a gift to you.
Okay.
So while on the speaking point, I could branch off to the third way, which is the gift.
Yes.
I think I was talking about something else, and I branch off to tell you about the inheritance. I ramble on when I'm talking land law, because as Wendy said, it's a very interesting and exciting area.
Yes, it is. So gifts, because I would love for somebody to give me a gift of land. Why not? So how do the gifts come? And then what is up with this dollar? I hear some people say, I don't know if it's true. I don't know if it's
about a dollar?
About, yes, this dollar. What I put, quote unquote, purchased, but it's only $1 for the land. What is that? Anyway, so I hope I don't, let me not throw you off, but go to gift, and I don't know where did that dollar. Yes.
You know what? Let me tell you about the dollar.
No problem. I have gift written down, so we won't forget. Tell me, how did this dollar come about, owning something for only $1? I want to get in on that.
When I was rambling on in my ramblings about what a deed would look like, because basically I was telling you, reading out a conveyance, a short form or simple conveyance to you earlier, when I was telling you start prepared by and so forth, right? And part of the clauses that I would have spoken about was you said the purchaser paid consideration of the sum of $100,000, and the vendor acknowledged receipt of it. We go back to the dollar. So what would make a transfer a sale, and what would make us a gift is based on the kind of consideration.
Okay.
Let's start with a conveyance is a form of a contract.
Okay.
Simple law.
Yes.
Every conveyance is a type of contract.
Yes.
You have a contract between two people to buy a ticket to go to a show, to go on the bus.
If
you're going on the bus, that's a simple contract. Contracts happen in our everyday life, and we don't even see them as a contract, and they're not even written.
The supermarket.
It's a contract.
It is a contract.
You walk in there, they could tell you go back up. You pick up your stuff, they could tell you put it back. But once you've brought it to the cashier,
and you paid,
and they would scan it, right? They're making the offer that you're receiving by paying your money, right? So that's a contract again, and they'll give you a receipt to show that you've paid. So the conveyance is a form of contract. But every contract must have consideration. There are some parts of a contract. We can talk about contract law another time.
Oh, yes.
And that would take a few,
sessions
10 sessions.
Oh, my goodness.
But so your conveyance have to have consideration. When it's a sale, the consideration is money.
Right.
The $100,000 or the $1. Because the $1 is almost, let's call it ceremonial.
So it's not about how much money?
It's not about how much. Any contract, it's never for any contract, it's not about how much. It must be valuable consideration. And valuable consideration is a thing of value. And the thing could be love, which is what happens with a gift. So the consideration, if I am giving Wendy, my dear friend and colleague, a gift of a lot of land, I could give her the land. The consideration of that land would be for my natural love and affection for her,
but they can't
and
write
other
that
diverse good causes. And it is written in a standard conveyance deed of gift. So if you have if you're doing a deed of gift, your consideration in that clause,
the cost of it is
cost
your love?
of it, your love and affection. So in your recitals, for instance, you say, whereas this person is my friend, and I've decided to make provision for that person, Wendy, by giving her a lot of land. You describe the land, and or your sister. Yes. Or your brother, you might give your sister this lot of land for your natural love and affection and other diverse good causes. You might give the land to the Conference of Churches for good causes, for charity, for the purpose of philanthropy.
Right.
That in itself is a consideration. Okay, but there must be consideration, and consideration must be valuable consideration, something of value.
Right.
Remember, and we sisters and brothers in Christ, value is not only money.
Of course not.
There's lots of non-tangible, intangible, considerations or valuable things. So that is a deed of gift. So it distinguishes a deed of gift from a conveyance, because that $1, it's now money. So the consideration is value of money, and then you would have a deed of conveyance instead of a deed of gift with this $1 consideration that was exchanged. And it will be recorded in a different way. It will be taxed in a different way, because in inland revenue, consideration is $1. It's a sale, whereas a gift has certain exemptions and waivers of tax, property transfer tax.
Really?
A sale does not track them. And you may sell it for $1, but in inland revenue, they may still value
the land
as whatever, and you may pay your taaxes on that.
Okay, hold on.
But you may not want. There might be reasons unknown to us why somebody may want to do that. I know they do it with I don't want to be political, but they do it with certain deeds, for instance, with governments and big contracts and so on. Private individuals can do it as well.
Okay.
But,
where you don't want to say
you gifted it.
I gift, just to avoid that.
Yes.
I sold it. So
I sold it.
So it could be $1, $5. It doesn't matter. It's just that it's 50 cents. Okay.
So no, I don't know if 1 cent and 2 cents don't
don't exist anymore. But okay. But I get you. Okay.
Yes.
So that is how that comes up. Okay. Whew. All right, let's go back to the gift.
The gift.
So we'll go back to gift now.
Right. So the gift happens when one person is desirous, they desire to make provision to another person. They don't want to sell the land to that person for whatever their good reasons, good causes are. Could be that the person was really good to them. Could be the person is a son or a daughter, and they just want to. The person got married on the your child getting married. You want to give them a startup, so you give them a piece of land, maybe with a small house, cottage on it, so they can start their family there. And it's very advisable if you want to make provisions for your children to give the land when they're alive. When you're alive, sorry, not when they're alive. That can when you're alive. So that it solves some of the mystery and some of the possibility for conflict after you've gone.
So even if they don't settle on it, or even if they're younger, so does it have an age to gift?
No, there's no age to gift. But of course, if you're giving a property to minor, you would have to set it up as a trust.
We'll talk about trust.
Yes,
I have it down
as
That's
trust.
another. Wills and trusts we'll do together.
Right? Because remember, we spoke about a conveyance is a form of contract.
Yes.
And minors do not enter into contract. But a contract can be made for the benefit of a minor.
Okay.
So you can gift it to them because it's for their benefit. Note well, just a point of importance here is that once a person conveys a property, whether by gift or sale, they no longer have an interest in it. So even if you give your child your property, you must know that you can't take it back. It's only if the child decides to give it back.
Really?
And sometimes bad things happen after children. Unfortunately, where I sit as a lawyer, I sit in a place where sometimes there's so much conflict dealing with family. And land and so. And sometimes parents give their children the land because they say, I was going to put it in my will, so I might as well give them while I'm alive. And they give the child a family house, and then the child wants to put them out of the house. And that's a terrible thing.
It's terrible, but it is legal. Because they gave it.
It is legal because they're now the legal holder of the land.
Oh my word.
Unless you can prove that there was some sort of secret trust for you to stay in it as long as you live.
Right. But if there were
but
no
if you
such
don't
provision.
have any provision there, and if you didn't have it, something to prove, you're not able to prove. Everything in law is a question of proof.
Oh boy.
You know, and if the child, sometimes they just give up because they feel so betrayed and overwhelmed that they just give up on fighting that. So be good and do good. I like to tell, that's one of my favorites, Wendy. I like to say, be good and do good. So I'm telling the viewers, be good and do good.
But then that little piece of advice that you gave a while ago, which is to try to do certain things before you die. Now this last piece kind of puts you in an imbalance.
You have to know. You have to know who you're gifting land to.
Sometimes you thought you knew,
and sometimes you thought you do.
And
or you can do it in a will. You can do your will, your last will and testament, and that will be a gift, but it would be after you die. The gift would take effect.
And we will certainly be dealing with wills and trust.
Well,
we'll do that in another.
But it is a way of conveying land too.
Okay.
If you feel uncomfortable with doing it, that you made provisions may not be made for you. Or there's a third way, and the lawyer can craft your deed in such a way that you give yourself life interest in the land, and you give your child or children, as the case may be, the remainder, you make them remainder men. You give them the remainder of the land. The fee simple interest.
Yes.
So after you die, it kicks in and they end up with the title. So they cannot put you out while you're alive. And if you feel uncomfortable, that might be a good route to go.
Okay.
Right?
All right.
So you're gifting it to yourself and then you're giving it to yourself and perhaps your spouse for your lifetime. And after both of you die,
then
it goes to the
automatically.
children automatically.
Okay. So maybe, just maybe, for those of you who are out there, of course, we're not trying to be your advisor or your psychologist today, but we are trying to be very practical. So, and we do know that there are some real issues out there. It doesn't make sense we're trying to pretend that these things do not exist. They do. So if you are one of those individuals, especially you are a little bit, not a little bit, you are older and you might even be thinking, oh my God, I'm going to die soon. I'm ready to go. The truth is, this is not us telling you, oh, you're not going to die, because you do have to make preparations for that. We all do. But once you have those concerns already, you're wondering, you're looking around, can't make up your mind who to give, and you're already feeling that undercurrent, you want to have a conversation with a lawyer. And this is not me advertising Niaesha or the field of law per se. I'm just saying it is important. It is better that you do what needs to be done now, because a lot of the times you have a quote-unquote a good friend that you think you can just trust and put all your confidence in, and you tell them, well, I want this done and I want that done, and you swear that this person is going to ensure that what you wanted done gets done. Ooh, that's a whole different story, I'm sure, all by itself.
And sometimes the person may have very good intention, but there's no legal framework to execute what you're asking them to do. If you cannot do a word of mouth will, and you may tell the person, give this person this, do this, I want you to do this, and it may just not happen. We know in Grenada where there's a lot of children who are not born in wedlock. And if your parents, I mean, no, the law allows a father to have his name recorded on the birth certificate. But some parents still don't record the father's name on the birth certificate. And you may have, or people who were born before 1991 may not have it recorded at all. So your dad may pass away and you are not a beneficiary because you're not recognized in law. Unless you go to the courts, and now you have to get a lawyer for sure to go to the high court for an order for paternity,
and
so that you can claim your inheritance.
Oh boy.
You know, unless if there is a will, you would have and your name is there, because if he said to all my children, you still have to go to the court to prove that you are one of all his children.
Oh my word.
So, you know, I say there's never an age really to make a will, huh?
No,
and there's never an age to get your business right. You know,
but some people will say things like, well, I don't have much, so I don't need to do a will.
The little you have, you see, while you're on earth, you do what you have to do. And we're living in a world where there are legal documents to prepare, you do that. You're sick, you have to see the doctor. You need education, you have to go to school. So there are just rules of living and life, and I just say follow them. You know, and the more you know and the more you're informed, the better you're able to advise yourself as to what is necessary. Because we were trying, I think, we're trying to debunk certain myths we have. And if you don't know what is myth from what is truth, then you may not know what are the things you even, what services you need to explore.
Right.
But hopefully, I'm doing some, I'm shedding some light on some of the concerns, and that, or even areas you didn't think of. And perhaps that will help people say, well, you know, I didn't think about this at all. I'll think about it some more, and maybe next year I'll go see someone and have a consultation.
Well, that is at least hoping that God bless you with next year, because you have no guarantee that too. That's the truth. Yeah.
So exactly. So you start with a conversation, and the consultation fee is nominal.
Right.
So you do the consultation, and then they will take it from there to tell you what is it you need. And you can do it in strides. You take your time, you start with one thing, or you start with several things, but you take some time, and you have the lawyer get your work done to prepare yourself. Never buy land without a conveyance. Never buy land without seeing that the person you're buying land from has their title deed.
All right.
Yeah.
And not, remember, the deed is not a little, anything with just a little drawing all on one sheet of paper. That is not your deed. Niaesha, would you believe we are out of time? So, because of course we've stopped at a comma.
When it's nice, you do it twice.
Well, actually, you'll be doing it for the rest of the year. So, because we know for sure that we are nowhere close to being where we want to be, it means that you will be back. Thank you so much for coming.
Thank you for having me. It was a pleasure being here with you in studio. I'm hopeful that we can go and enjoy some nice environment. Grenada is sunny and it's dry season coming up.
One of these days,
And perhaps we can get to talk outside and see the land that we're so proud of.
So we will definitely consider that. I think you're telling me in a nice way, let's leave the studio and do this elsewhere. But it really was a pleasure. Thank you so much again for just availing yourself and doing, because this is a service. Is a service that that we all need. I know for sure that I'm learning a whole lot that I didn't even expect to get from this. So thank you so much again for coming. This is what the CCG does. We give information. Thank you for being with us today. Have a really great rest of your day and a wonderful weekend. Until we see again, you and I will be with another guest next Friday. God bless you.
You are